Welcome to the lecture entitled Race-Based Affirmative Action is Not Morally Impermissible. I'm Andrew Chapman. In this lecture, we'll discuss 9 topics. 1. Affirmative action and moral questions. 2. The 2 standard moral positions about affirmative action. 3. Boonin's non-standard position. 4. The argument from the right to be judged on one's individual merits. 5. The argument from the right to equal treatment. 6. The Overgeneralizations Argument. 7. The argument from discrimination. 8. The bad track record argument. And 9. The argument from the negative effects of affirmative action. In this lecture, we'll primarily focus on Chapter 5 of David Boonin's 2011 book, Should Race Matter? Unusual Answers to the Usual Questions. Chapter 5 is entitled 2 Cheers for Affirmative Action, Why There's Nothing Wrong with Not Abandoning Racial Preferences Either. Chapter 5 is the companion chapter to the previous chapter in that book, Chapter 4, which argues itself for the thesis that there's nothing wrong with not instituting racial preferences. That is, there's nothing wrong with not engaging in affirmative action policies. Boonin is a professor of philosophy and the director of the Center for Values and Social Policy at the University of Colorado, Boulder. Boonin's research focuses mainly on issues in applied or practical ethics such as abortion, legal punishment, race, and our duties to future people. Since the main subject of this lecture is affirmative action, it's important for us to recognize what affirmative action is. Says Boonin, a white candidate and a black candidate submit an application for a position. Both want to be admitted to the same university, hired at the same automobile plant, or promoted from their current jobs within the same police department. Both candidates are suitably qualified for the position. If either of them were the only one to submit an application, the organization in question would offer the position to that candidate without hesitation. The white applicant, though, is at least a little bit better qualified than the black applicant. His grades and test scores are a little bit higher, he has slightly stronger letters of recommendation, or he has a little bit more experience on the job. If the organization didn't know the race of either of the applicants, it would select the white applicant over the black applicant for this reason. But the organization does know the race of both applicants, and it has a policy that leads it to select the black applicant over the white applicant, despite the fact that the white applicant is at least a little bit better qualified, precisely because the white applicant is white and the black applicant is black. This gives us an overall picture of the sort of thing that's being talked about when we talk about affirmative action. Affirmative action can consider many factors, including race and gender, but since we'll here be examining only race-based affirmative action, references throughout this lecture to affirmative action, whether qualified or not, are always going to be to race-based affirmative action, and the arguments herein will apply specifically to race-based affirmative action, even if those arguments might also apply outside of the sphere of specifically race-based affirmative action. Affirmative action can be divided into a strong sort and a weak sort. Weak affirmative action involves making sure that members of specific racial groups are aware of, are able to apply for, are able to interview for jobs, college admissions, etc. Decisions in hiring or in admission, though, are made with no racial preference. Strong affirmative action, on the other hand, is preference given or positive attention paid to qualified members of specific racial groups in decisions in hiring or admissions or other related decisions. Since almost no one finds weak affirmative action problematic, and since the debate over the morality of affirmative action has tended to center on the morality of strong affirmative action, we will focus here on strong affirmative action. Thus, references to affirmative action throughout are always both to race-based affirmative action and strong affirmative action. Affirmative action, that is, strong race-based affirmative action, is an active rather than a merely passive set of policies in choosing between candidates to occupy a limited number of positions in arenas such as education, employment, and housing. These active policies institute preferential treatment in the selection of candidates for otherwise qualified applicants who are members of specific groups or populations. So, for example, women or black people or first-generation college students. This preferential treatment can be enacted in a number of ways, including quotas or weighting or picking a member of a specific group or population over a non-member in X% of cases. It's important when discussing the issue of affirmative action to make the distinction between practicality, law, and morality. Both proponents and critics of affirmative action are concerned with both the practicality and the legality of affirmative action policies. In terms of practicality, it might be wondered whether affirmative action policies are feasible or even possible within a given organization. In terms of legality, it might be wondered whether affirmative action policies are required by, or whether, on the other hand, they violate any specific local, state, or federal laws. While considerations of practicality and legality are important, we will here be concerned solely with moral questions regarding affirmative action. The morally right thing might sometimes be impractical, or the law might sometimes not be in line with morality. What we're concerned with is what, when considered on its own merits, affirmative action's moral status is. In traditional discussions of the morality of affirmative action, almost all thinkers take one of two mutually exclusive positions. The first position is that affirmative action is morally impermissible. This would mean that it would be morally wrong to institute affirmative action policies and morally required not to institute affirmative action policies. The second position is that affirmative action is morally obligatory. This would mean that it would be not only morally acceptable to institute affirmative action policies, but further that it would be morally required to institute affirmative action policies, and that it would be morally wrong not to institute affirmative action policies. Proponents and opponents of affirmative action can sometimes take questions concerning the moral status of affirmative action to stand in for all moral questions concerning race or gender or education or employment or hiring or rights or fairness or justice. But that is simply rhetorical hyperbole that we shouldn't pay attention to here. neither the proponent nor the opponent of affirmative action needs to be saying any of the following: that all forms of affirmative action have the exact same moral status, that there are no considerations relevant to selection other than race or gender, that affirmative action requires selecting unqualified candidates, that some candidates are more morally important than are other candidates, or that all issues of racial or gender justice stand or fall with the affirmative action question. The two standard positions that affirmative action is impermissible and that it's obligatory are mutually exclusive, which means that they can't both be true simultaneously, or one person can't hold both of them simultaneously. But those two positions aren't jointly exhaustive, meaning there are other possible positions than just those two. According to Boonin, affirmative action policies are permissible, but not obligatory. What this means is that while it would be morally fine for an organization to institute affirmative action policies, it would also be morally fine for an organization not to institute affirmative action policies. Thus, according to Boonin, both sides of the standard debate are wrong. Affirmative action is neither obligatory nor impermissible. Instead, it is non-obligatory but permissible. Now, this can at first seem non-committal on Boonin's part, as if he's just saying something like, oh, well, just do whatever you want, it doesn't really matter. But it's important to recognize that he is not saying that affirmative action doesn't matter morally. He's saying affirmative action matters morally a great deal. However, the way that it matters occupies a middle ground between impermissibility and obligatoriness. Affirmative action is neither impermissible nor obligatory, and that is as firm a moral status as something being impermissible or something being obligatory. In claiming that affirmative action is permissible but not obligatory, Boonin is claiming that this is the fundamental moral status of affirmative action. That is, when considered on its own, apart from surrounding merely contingent factors, affirmative action is permissible but not obligatory. That doesn't mean that there aren't contingent factors that might make specific instances of affirmative action obligatory or impermissible. So consider, for example, a company that promises to institute affirmative action policies and then fails to do so. That company would have done something wrong. It would be obligatory for that company to institute affirmative action policies, but not because of the obligatoriness of affirmative action, because instead of the obligatoriness of keeping one's promises. Or consider that a school institutes affirmative action policies by lying about the qualifications of certain applicants. That school would have done something morally wrong, and thus it would be impermissible for that school to institute affirmative action policies in that way, but not because affirmative action policies themselves are impermissible. What's impermissible is lying. So in each of these examples, it is not affirmative action itself that is driving the obligatoriness or the impermissibility of affirmative action. It's promises or lies entirely apart from the properties of affirmative action itself. So we shouldn't confuse the moral status of affirmative action with the moral statuses of things contingently related by circumstance to affirmative action. If we're concerned with the moral status of affirmative action, that is all we should pay attention to. Since Boonin uses the example of what he calls geographical affirmative action throughout the chapter, it's important for us to get clear on this notion. What is geographical affirmative action? Consider a form of affirmative action, call it geographical affirmative action. Geographical affirmative action policies are implemented when preference is shown for otherwise qualified candidates because of the specific geographical region those candidates come from. Here's an example. A school might institute geographical affirmative action by setting geographical quotas for its incoming class. They might say that X% should come from the Northeast, Y% from the Midwest, Z% from the South, and so on. An organization might have many reasons for instituting geographical affirmative action policies. A main reason could be that the organization values the diversity in background and culture that comes from geographical diversity. Here's something interesting to note. No one seems to have a problem with geographical affirmative action, and no one seems to think that geographical affirmative action is morally required. There have never been lawsuits filed because an organization practices or doesn't practice geographical affirmative action, and no one writes philosophy books about geographical affirmative action. Thus, it seems as though people treat geographical affirmative action very differently than how they treat race-based affirmative action. If this differential treatment is justifiable, then there will need to be something morally different between geographical affirmative action on the one hand and race-based affirmative action on the other. According to Boonin, and this shows up in the companion chapter, chapter 4 to this chapter, we can use the moral similarities between geographical affirmative action and race-based affirmative action as an argument for his thesis that race-based affirmative action is permissible but not obligatory, and that is the thesis of chapter 4, the chapter prior to this one. That argument looks like this. There are no morally relevant differences between geographical affirmative action and race-based affirmative action. If two things are such that there is no morally relevant difference between them, then if one position has moral properties X, then the other position also needs to have those same moral properties X. Geographical affirmative action is permissible but not obligatory, and if 1, 2, and 3 are true, then race-based affirmative action is permissible but not obligatory. Let's turn now to Boonin's central argument in this chapter for the conclusion that race-based affirmative action is not impermissible. 1. The plausible arguments that have been proffered against the moral permissibility of race-based affirmative action are each defective in at least one way. 2. Unless there's good reason to believe that the defects with the plausible arguments that have been proffered for or against some position aren't themselves generalizable, then these defects are generalizable. 3. There isn't any good reason to believe that the defects with the plausible arguments that have been proffered against the moral permissibility of race-based affirmative action are not generalizable. 4. If the defects with the plausible arguments that have been proffered against the moral permissibility of race-based affirmative action are generalizable, then race-based affirmative action is not impermissible. That means it is permissible. And therefore, from 1, 2, 3, and 4, we can come to the conclusion that race-based affirmative action is not impermissible. Boonin's argumentative strategy in order to show that there are defects with the proffered arguments and that these defects generally appear as though they can be generalized to any other possible argument against the moral permissibility of affirmative action is to look at a series of arguments that have been given against the moral permissibility of affirmative action and to show how these arguments are deficient. Boonin extracts or plausibly reconstructs 6 different arguments against the moral permissibility of race-based affirmative action that are in the literature. These arguments are as follows. 1. The argument from the right to be judged on one's individual merits. 2. The argument from the right to equal treatment. 3. The Overgeneralizations Argument. 4. The argument from discrimination. 5. The bad track record argument. And 6. The argument from the negative effects of affirmative action. We will now look at each of these arguments in turn, see what the argument says, and see why Boonin thinks that there's something defective about each one of these arguments. The individual merits argument looks like this. The argument for this position typically goes like this. Each person has the right to be judged as an individual, not merely as part of a group. When a person is judged as an individual, all that matters is that person's particular qualifications. So, if each person is judged on their individual merits, the best qualified candidate will be selected. This means, in turn, that if each person truly does have a right to be judged on their individual merits, then the best qualified candidate really does have a right to be selected for the position he applies for. It follows from this that any decision procedure that deliberately selects a less qualified black applicant over a more qualified white applicant violates the better qualified white applicant's rights. And if that's true, then affirmative action is unjust and must be rejected for that reason. Let's now formalize that argument in premise-conclusion form so that we can see the specific claims that are being made and how those are supposed to support the conclusion that race-based affirmative action is morally impermissible. Premise 1. Race-based affirmative action judges people in ways that are not based solely on those people's individual merits. 2. People have a right to be judged solely on their individual merits. Thus, race-based affirmative action violates people's rights. 4. If something violates people's rights, then it's impermissible. Therefore, 5. Race-based affirmative action is impermissible. Now, clearly, the operative premise and the one most vulnerable to criticism is premise 2, that people have a right to be judged solely on their individual merits. Well, what's the problem with that claim? If people do in fact have a right to be judged solely on their individual merits, then there are a number of implausible consequences. Thus, if that right does exist, something problematic happens, and that gives us good reason to reject the existence of that right. Some of these consequences are that geography-based affirmative action would become impermissible, but geography-based affirmative action is not impermissible. Or hiring someone because you like their company's name or some other trivial fact about the company would become impermissible, but that's not impermissible. Or admitting applicants on a rolling admissions basis would become impermissible, since not all candidates' applications would be in when many of the decisions are made, but admitting applicants on a rolling admissions basis is not impermissible. Or Hiring people who have disabilities so as to employ them would become impermissible, but that's not impermissible. Now, perhaps in some of these cases, better choices could be made than the ones that are made, but the fact that X is a better choice than Y simply doesn't entail that choosing Y is morally impermissible or that choosing X over Y is morally obligatory. Now, a proponent of this argument might say, well, it's not merely the right to be judged solely on the basis of individual merit that is being violated here. Something else is helping to secure the moral impermissibility of race-based affirmative action. But if there's something in addition to the individual merits that is doing or helping to do the argumentative work in this case, then it's not an individual merit-based right that would be what makes affirmative action wrong. Something else entirely would be what is making affirmative action wrong, and we would need to investigate what that other thing is to see whether it's actually true that that other thing makes affirmative action wrong. The next argument is the argument from equal treatment. The argument based on the right to be treated equally with others is typically restricted to cases involving affirmative action as practiced by some branch of the government. Carl Cohen, one of the most prominent philosophers to have argued against the practice of affirmative action in public institutions, has written that every applicant to a state university has a right under the U.S. Constitution to the equal protection of the laws. Where goods are in short supply, as are admissions to a fine state university, advantages given to some by race inevitably result in disadvantages imposed on others by race. To give by color is to take by color. That is the denial of the equal protection of the laws. Let's put this argument in premise-conclusion form. 1. Individuals in cases of type X have a right to equal treatment. 2. Race-based affirmative action policies treat people differentially based on race. 3. Differential treatment based on race in cases of type X is unequal treatment. Thus, affirmative action policies in cases of type X violate the rights of individuals to equal treatment. 5. If something violates people's rights, then it's impermissible. Therefore, our conclusion: race-based affirmative action is impermissible in cases of type X. And notice that in this argument, race-based affirmative action will only be impermissible in particular sorts of cases, and those sorts of cases will generally be ones where it's admissions to or hiring in or housing in something that's publicly owned rather than privately. A right to equal treatment is ambiguous. We can distinguish a stronger and a weaker form of such a purported right. The strong form of a right to equal treatment is this: a person, A, has a strong right to equal treatment if and only if, for any other person, B, and for any possible circumstance, C, A and B ought to be treated exactly the same in C. And the weak form of the right to equal treatment looks like this: a person A has a weak right to equal treatment if and only if, for any other person B, for any property of A and B, P, and for any circumstance, C, in which P is not relevant, A and B ought to be treated exactly the same in C. Notice that the weak right adds in the circumstance and the relevance of a particular property to that circumstance, and says that the weak right obtains if and only if some particular property is not relevant to that circumstance. The strong right, however, has problems, says Boonin. Suppose, for example, that the CIA is considering two candidates for an undercover assignment in an overwhelmingly black African country. One of the candidates has a bit more experience and a bit more knowledge of surveillance techniques than the other, but the somewhat more experienced and knowledgeable agent is white, while the somewhat less experienced and knowledgeable agent is black. Or suppose that a national park is auditioning two actors to portray Abraham Lincoln in an educational program for visiting school children. One of the candidates is a somewhat better actor with more performing experience, but he is black, while the somewhat less talented and experienced candidate is white. Or the National Institutes of Health is looking for participants in a study to determine whether a particular drug is especially effective in treating hypertension in African Americans. Virtually everyone, regardless of their view about race-based affirmative action, will agree that it is morally permissible for the state to take race into account in these cases when deciding how to treat the people in question. Thus, if certain circumstances can make it permissible to treat people differently, then the strong right, which says that people should be treated exactly the same regardless of circumstance, clearly is not a right that anyone possesses. Let's turn to the weak right. Unfortunately, the weak right also has problems. Suppose that we do have a weak right to equal treatment. The question then becomes, is race relevant to justifiable differential treatment? That is, can racial differences justify treating people differently? The reason why this is the question is that we are trying to figure out what sorts of properties are relevant to specific circumstances of differential treatment and what sorts of properties are not. If race isn't relevant, then race-based affirmative action won't be permissible, but if race is relevant, then race-based affirmative action will be permissible. That's just what the weak right requires us to figure out. However, that's the exact same question as the question the right to equal treatment was invoked in order to answer in the first place, whether racial differences are relevant to permissible differential treatment. So the problem is this. In order to answer the question, is differential treatment based on race permissible? That is it permissible to institute policies such as affirmative action policies? We would need to answer the question, is race relevant to justifiable differential treatment? But in order to answer that question, we would need to know whether differential treatment based on race is permissible. Thus, we can't assume that race either is or is not relevant to permissible differential treatment when we're talking about the weak right, because to do so would be to presume the answer to the question that we're invoking the weak right in order to try to answer. So the weak right, far from justifying or not justifying the permissibility or impermissibility of race-based affirmative action, does nothing more than say, if race-based affirmative action is permissible, then it's permissible, and if it's not permissible, then it's not permissible. But that doesn't help us. Here's some explanation. Says Boonin, a policy violates someone's right to equal treatment in the weak sense if it treats race as relevant in circumstances in which race shouldn't be treated as relevant. And so affirmative action will violate the right to equal treatment in the weak sense only if it treats race as relevant when race shouldn't be treated as relevant. But whether or not race should be treated as relevant in the kinds of circumstances in which affirmative action programs exist is precisely the question at issue. Defenders of affirmative action maintain that race should be viewed as relevant in such cases, while opponents of affirmative action maintain that race should not be viewed as relevant. In order to argue against affirmative action by appealing to the claim that affirmative action violates the right of equal treatment in the weak sense, then, the opponent of affirmative action must first assume the very thing he is trying to prove, that affirmative action takes race into account when it shouldn't. But perhaps there are formulations of a right to equal treatment that are either intermediate between the strong and weak forms of the rights in their strength, or based on some other principle entirely. Here are two plausible candidates. One, call it an intermediate strength right to equal treatment, looks like this. A person, A, has an intermediate strength right to equal treatment if and only if, for any other person B, for any property of A and B, P, and for any circumstance C in which P is irrelevant specifically to a person's performance of some function in C, then A and B ought to be treated exactly the same in C. So note that the intermediate strength right adds in the relevance of the property to the performance of a particular function or skill within a circumstance. The second alternative formulation of this equal treatment right can be called the strict scrutiny right to equal treatment. Looks like this. A person A has a strict scrutiny right to equal treatment if and only if, for any other person B, and for any circumstance C, A and B ought to be treated exactly the same in C, unless treating A and B differently in C promotes a compelling state interest, and treating A and B differently in C is the best way to promote that compelling state interest. But, as you've no doubt guessed, there are problems for both of these formulations. Let's look at a problem for the intermediate strength right. This formulation has the exact same problem that the weak equal treatment right had. It raises the very question that it's being invoked in order to try to answer. Thus, whether the right applies hinges on whether differential treatment based on race is justifiable or permissible in the first place. Whether race is relevant to the ability to perform a job is again at issue in deciding whether race-based affirmative action is permissible. For example, a person hired in part due to race-based affirmative action policies intended to promote workplace diversity is only able to perform her job as a person who increases workplace diversity due to her race. Thus, if affirmative action policies are being instituted for the normal reasons that affirmative action policies are instituted, then nobody other than a beneficiary of affirmative action, or somebody who could be a beneficiary of affirmative action, could possibly perform the job that is being performed or that is relevant. If somebody says, no, race is irrelevant to the performance of this job, then they are simply presuming an answer to the question that we've tried to set out to answer. A second problem with the intermediate strength right is this. Suppose, for example, that a man names an executor in his will and directs him to disperse his considerable assets as he sees fit among organizations that give money to Black Americans. And suppose a dispute arises over whether or not the money is being distributed in a manner consistent with the terms of the will. A judge steps in to resolve the dispute. In this case, at least, it should be clear to everyone on both sides of the affirmative action debate that it would be perfectly appropriate for the government to treat the race of people getting the money as relevant in deciding what to do. But the proposed intermediate version of the right to equal treatment would be unable to account for this judgment. The version says that race may be considered only when it's relevant to the performance of a particular job, but in this case, race is relevant for a very different reason. It's relevant because a certain action in the past generated an obligation to give preference to Black Americans over white Americans in distributing the money in question. So let's turn to the strict scrutiny right. What would be the problem with that sort of right? One that says the only permissible differential treatment based on something like race is when that differential treatment is the best way to promote a compelling state interest. Says Boonin, the strict scrutiny standard, too, has implications that virtually everyone on both sides of the affirmative action debate will reject. Consider, again, the case of the national park that wants to hire an actor to portray Abraham Lincoln in an educational program for school children. Or perhaps it wants to hire someone to portray Frederick Douglass, or to reenact scenes involving slaves and their masters. Virtually everyone would agree that it's morally permissible for the organizers of the event to take race into account when deciding which actors to cast in which roles. But it's clearly implausible to say that doing so is necessary for serving some compelling state interest. If people have a moral right not to have the state take their race into account unless doing so is necessary to serving some compelling state interest, then people have a moral right not to have race taken into account in this case. Why is it that proponents of the right to equal treatment argument against race-based affirmative action generally exempt private organizations from an obligation not to violate the purported right to equal treatment? Those who make this move face a dilemma. For any right, either that right is inalienable or it's not. If the right is inalienable, then the obligation not to violate that right applies equally to both private and public organizations. If the right is not inalienable, then there is no rights-based reason why public organizations have an obligation not to violate that right. We can't simply rely on the public-private distinction to answer this question, since there are some rights that it's impermissible for both public and private organizations to violate. For example, a person's right to her own bodily integrity. Thus, if there is a distinction here in terms of rights, it relies on something deeper than just the public-private distinction. So what could justify invoking the public-private distinction in order to say that it is permissible in cases of private organizations, but impermissible in cases of public organizations to take race into account? It has to be something more than just the bare distinction between public and private. Here's a possible justification, says Boonin. The reason that the difference between public and private institutions matters so much is that tax dollars go to support public institutions in a way that they don't go to support private institutions. Suppose, for example, that I'm a white high school senior in California and that I've applied both to Stanford and Berkeley. Stanford isn't funded by my tax dollars, and so on this account, I don't have any particular right to have Stanford make its admissions decisions in one way rather than another. But Berkeley is supported by my tax dollars, and so, the argument maintains, I have a right to be given exactly the same amount of consideration as anyone else when Berkeley makes its decisions. I have to pay my taxes that go to Berkeley just like anyone else, and so Berkeley should have to treat me just like it would treat anyone else. If Berkeley gives preferential consideration to black applicants over white applicants, that is, then it violates my right to equal treatment in a way that Stanford's giving such preferential consideration wouldn't. However, what about the students that are within the domain of taxpayers versus those that are outside of the domain of taxpayers? Now we don't have the same problem so long as race-based affirmative action isn't applied to students of differing races from within the tax-paying zone. This isn't so much supposed to be a plausible solution to this problem as it is supposed to be a problem with this proposal. This seems very implausible that we can impose differential race-based treatment so long as the people who we're applying it to don't pay taxes that go directly to funding a particular organization. But further, there's a difference between adopting a race-based affirmative action policy in order to make racial distinctions and adopting such a policy in order to promote some other goal. Consider the difference between these two claims. Black people are more important than white people, so we should favor them in admissions, and racial diversity is important, and racial diversity will be best achieved by favoring black applicants over white applicants, so we should favor black applicants over white applicants in admissions. If we have a right to equal treatment, it protects us from the first sort of unequal treatment and not from the second sort of unequal treatment. Since in the second sort of unequal treatment, the unequal treatment isn't the end, it's not the goal, it is a means to some end. The next argument is the Overgeneralizations Argument. Says Boonin, suppose, for example, that a university admits some black students with grades and test scores that are lower than the grades and test scores of some of the white students that it rejects. And suppose that the school attempts to justify its right to do so by appealing to some claims such as black students have had to overcome race-based obstacles that white students have not had to overcome, or black students would bring a distinctive point of view to campus that adding more white students would not. What's supposed to be the problem with such a justification? Let's look at a formalized version of this argument. 1. Race-based affirmative action policies necessarily involve the making of overgeneralizations about people based on their race. 2. The sorts of overgeneralizations about people based on their race involved in race-based affirmative action policies provide benefits to some people who do not merit benefits and withhold benefits from other people who do merit benefits. Providing an unmerited benefit or withholding a merited benefit is impermissible. Therefore, race-based affirmative action is impermissible. Says Boonin, yes, the critic of affirmative action will agree many black students have had to overcome race-based obstacles, but not all of them have, and yes, they will continue, many black students would bring a distinctive point of view to campus, but not all of them would, and furthermore they will add, some white students have had to overcome race-based obstacles, and some would bring a distinctive point of view to campus too. So while having been racially disadvantaged or having a distinctive point of view may in themselves prove to be relevant considerations, these critics will conclude it would be wrong to give preference to black students over white students on such grounds because this will provide a benefit to some students who don't really merit the benefit. And it will withhold a benefit from some students who really do merit the benefit. The point here is that relying on somebody's race in order to tell whether they merit being benefited or not by a policy overgeneralizes such that some people who should be benefited won't be, and some people who shouldn't be benefited will be, even if some people who should be benefited are benefited and some people who shouldn't be benefited are not benefited. Thus, race and meriting a benefit don't vary in exactly the right sorts of ways. However, it's false that all race-based affirmative action policies rely on overgeneralizations about people based on their race. This is not at all the only way to implement or reason for enacting race-based affirmative action policies. Thus, a proponent of race-based affirmative action policies might say, yes, overgeneralizations are bad, but race-based affirmative action policies don't necessarily overgeneralize. So if there really is a problem with overgeneralization, that is not essentially a problem with race-based affirmative action policies. But even if race-based affirmative action did necessarily rely on generalizations and overgeneralizations, so do many other things that almost nobody thinks are impermissible. There are many, many examples of these, so here are some of them. Geography-based affirmative action, driving age, voting age, drinking age, age of legal adulthood, age at which one can smoke, age at which one can marry, age at which one can join the military, age at which one can run for different elected offices. In fact, generalizations about hardship or experience or viewpoint based on race are likely more accurate than are any of these other generalizations. Just being 16, does that make somebody mature enough or competent enough to drive? It's totally unclear. Some 16-year-olds perhaps, but some people might be ready to drive at 14. Some people might never be able to drive. And so these sorts of generalizations, even if they are in place, are obviously not always bad, because most people think that such generalizations in cases outside of race aren't themselves always bad. Someone might claim that race-based affirmative action does not benefit the most disadvantaged members of the racial classes it seeks to benefit, and that this is a problem. Instead, they might claim it benefits the least disadvantaged members of those classes and does nothing for the most disadvantaged members. Thus, we can see that this is an addendum to the sort of argument that we were already talking about in terms of overgeneralization. So even if affirmative action policies do end up benefiting people who are disadvantaged, they don't benefit the people who are most disadvantaged. But is this even true? There's simply no reliable evidence to back this claim up. At most, it relies on anecdotal or knee-jerk seemings or pieces of evidence about the effects of race-based affirmative action, where somebody can point to particular situations or can point to how things seem they might be and say, well, isn't it just obvious that the people who would be benefited most are the people who are able to take advantage of those benefits, and thus the people who are least disadvantaged are the ones who end up being benefited most. Maybe, but we simply have no good evidence that would show us that that is the case, and we shouldn't rely on mere anecdote or mere knee-jerk seeming when we're trying to decide the morality of a policy. However, even if it were true that affirmative action policies only benefited the least disadvantaged members of some disadvantaged class, why would not benefiting the most disadvantaged members of some class make a policy impermissible? Even if not benefiting the least disadvantaged members of some class made a policy not ideal or even flat out bad, less than ideal or even bad policies are not thereby impermissible policies. So clearly there is a false assumption that's running in the background of the argument of the person who says affirmative action is bad because it doesn't benefit the most disadvantaged people, the least well off. They seem to think that the only permissible policies are those that benefit the most disadvantaged people. But why would this be true? The next argument is the argument from discrimination. Says Boonin, if there were an argument that started from the assumption that past forms of discrimination were wrong, and that ended by showing that affirmative action today is wrong, it would be a very powerful argument indeed. Such an argument goes like this. If it was wrong for racial discrimination to favor white people over black people in the past, then it's wrong for racial discrimination to favor black people over white people in the present. It was, in fact, wrong for racial discrimination to favor white people over black people in the past, so it is, in fact, wrong for racial discrimination to favor black people over white people in the present. Affirmative action is a form of racial discrimination that favors black people over white people in the present. Therefore, affirmative action is wrong. Now let's formalize this argument. There are, in fact, two slightly different forms that this argument might take. Here's the first form. 1. Past racially motivated mistreatment of black people was impermissible. 2. Race-based affirmative action and past racially motivated mistreatment of black people are morally analogous in that they are both forms of racial discrimination. Therefore, race-based affirmative action is impermissible. This form of the argument draws a moral analogy between two forms of discrimination and says if one of them was wrong, the other one must be wrong. Since the first one was wrong, the second one must be wrong. Here's the other form of this argument. Race-based affirmative action is a form of racial discrimination. All forms of racial discrimination are impermissible. Therefore, race-based affirmative action is impermissible. No argument from analogy is being made here. The claim is simply that if anything is a form of racial discrimination, then that thing is impermissible. However, the claim of moral analogousness in the first form of the argument and the claim that all forms of racial discrimination are immoral in the second form of the argument are both false claims. Both of those claims rely on the assumption that if some act, A, is wrong in one context, X, then for any other possible context, Y, A would also be wrong in Y. But that assumption is clearly and obviously false. For example, consider the issue of killing. If it's immoral for me to kill you today, does that mean that killing is always and everywhere immoral? Of course not. Consider cases of self-defense in which killing is the only possible option. What makes killing wrong in one case and permissible in another case is not that the killing itself has changed, it's still killing in both cases, but instead that the particular circumstances surrounding the killing have changed. Thus, to say that something was wrong, therefore it is always wrong, is to ignore the fact that circumstances can change the wrongness of that thing. In the case of racial discrimination, one of the relevant circumstances morally is the reason for and the use of racial discrimination. So one of the things that makes racial discrimination have the moral properties that it does is the reason and use of that racial discrimination. Says Boonin, discrimination against black people in the past took place in a specific context. It was used as a means of expressing the white majority's contempt for and feelings of superiority to the black minority. And so our rejection of this objectionable form of behavior commits us to the view that it would also be wrong for black people to use racial discrimination as a means of expressing contempt for or feelings of superiority to white people. But no one seriously believes that contemporary race-based affirmative action does anything of the sort. If a state university today admits a somewhat less qualified black applicant over a somewhat more qualified white applicant, it's perfectly clear that the university's act in no way expresses contempt for or disapproval of the white applicant in particular, or white people in general. Next is the bad track record argument. Says Boonin, this argument against affirmative action appeals to the claim that this country has a bad track record when it comes to treating people differently according to race. In the past, the argument points out, policies that treated people differently along racial lines almost always resulted in injustice. And because this is so, the argument concludes, policies shouldn't treat people differently along racial lines today. Affirmative action policies do treat people differently along racial lines today, and so, according to this argument, affirmative action policies are wrong. Here is a formalized version of the argument. 1. Historically, policies that have treated people differently along racial lines have had negative consequences. 2. If a policy historically has had negative consequences, then such a policy is immoral. 3. Race-based affirmative action treats people differently along racial lines. Therefore, 4. Race-based affirmative action is immoral. Note that premise 2 relies on the implicit claim that historically bad policy would also be bad in the present. Further note that that claim itself relies on the implicit claim that mistakes made in the past with respect to some policy cannot be, or at least have very little chance of being, successfully remedied in the present. I think the problem with this argument should be clear. The claimed problem here isn't with the policy itself, but with the incompetent implementation of the policy. Says Boonin, the fact that something used to be done incorrectly in the past provides no reason not to do it correctly today, though it may well provide reason to be cautious in attempting to do so. And the fact is that our government has a pretty bad track record with respect to all sorts of distinctions. The law, for example, distinguishes between adult and child, citizen and non-citizen, innocent and guilty, mentally competent and incompetent. But in all of these cases, the distinctions have sometimes been misused in the past. But in none of these cases does it seem plausible to conclude that the government should therefore never draw the distinctions in the present. And so the same goes for the distinction between black and white. The fact that this distinction was misused in the past can't, by itself, give us reason to think that it must be wrong to use it differently in the present. The next argument is the argument from negative consequences. Says Boonin, the claim is that affirmative action has a stigmatizing effect on the very people it's supposed to benefit. If everyone on a given college campus knows that the black students there were admitted under a relaxed set of standards relative to the white students, for example, the argument maintains that two things are likely to happen. First, the white students are likely to think less of the black students. Second, the black students are likely to think less of themselves. Stephen Carter, for example, writes of the terrible psychological pressure that racial preferences often put on their beneficiaries. And many other authors have maintained that being admitted or employed as a black person under an affirmative action policy induces self-doubt. Here's a formalized version of that argument. 1. Race-based affirmative action has negative consequences. 2. If something has negative consequences, then that thing is impermissible. Therefore, 3. Race-based affirmative action is impermissible. This argument is consequentialist in nature. Consequentialism is a normative ethical theory that holds that it is the consequences of an action alone that determine the moral status of that action. Consequentialist arguments are generally taken to give comparative moral conclusions about whether an action is better or worse than the relevant alternatives. Even if we assume, though, that it's the case that race-based affirmative action has negative consequences, and this is not a fully justified assumption. Evidence in favor of the claim that race-based affirmative action has negative consequences is generally speculative and anecdotal at best. But even if that's the case, the fact that something has bad consequences proves at best that there may be better options, but not that the thing is flat out impermissible. Consider, I tell you that if you let me borrow your car, I'll put gas in the tank before I return it to you. I use 5 gallons of gas and I put 4 gallons back in the tank, which makes you upset. The fact that you're upset, at best, shows that there was a better option for me than putting only 4 gallons in the tank. But does it prove that putting 4 gallons in the tank was flat out impermissible? Certainly not. The argument from the purported negative consequences of race-based affirmative action is most often stated in terms of resentment and stigmatization, as we've already seen. However, there are a few other variations of this argument that run on the same argumentative principles. One variation is in terms of race relations. It says that race-based affirmative action produces negative consequences in terms of the worsening of or the prevention of the improvement of race relations or relations between different races. Another variation is in terms of efficiency reduction. It says that race-based affirmative action produces negative consequences in terms of reducing the efficiency of organizations that are practicing affirmative action. And a final variation is in terms of affirming differences between people. It says that race-based affirmative action produces negative consequences in terms of impairing our ability to treat all people equally. Let's look at each of these variations in turn. First, the claim about negative consequences in terms of race relations. Says Boonin, the argument here is that affirmative action is wrong because it's divisive, creating rifts on campus, in the workplace, and throughout society in general. This kind of argument strikes me, that's Boonin, as puzzling. Affirmative action is certainly a divisive subject, but it seems strange to blame one side rather than the other for that fact. The debate over abortion rights, for example, is at least as divisive as the debate over affirmative action, but imagine a defender of abortion rights suggesting that pro-life protesters should abandon their cause because the abortion controversy is tearing the nation apart. Surely, in that case, it would be clear that the pro-life protesters would be entitled to reply by suggesting that the abortion rights advocates abandon their cause for precisely the same reason. It's true that if people stopped trying to outlaw abortion, the issue would no longer be so divisive, but it's equally true that if people stopped trying to prevent abortion from being outlawed, the issue would no longer be so divisive. The divisiveness of the abortion issue, in short, provides no reason to come down on the side of one or the other of its participants. Thus, when we talk about race-based affirmative action, the fact that the issue is divisive doesn't mean that we either should or should not find that race-based affirmative action is morally permissible. It has nothing to do with the permissibility of race-based affirmative action that people find the issue itself divisive. Next, the efficiency reduction variation, says Boonin. The argument is that if a company fails to hire the best qualified candidate for any given position, on this account then, productivity will go down. If a college fails to admit the best students, then graduation rates, including black graduation rates, will go down. Boonin continues, however, when my neighborhood supermarket hired the grocery store bagger with Down syndrome, for example, they failed to maximize the efficiency of their operation, but no one thinks that what the store did in hiring that worker was immoral for that reason, because no one really thinks that there's a moral obligation to be as efficient as possible in the first place. And since it isn't immoral to fail to be as efficient as possible, the fact that affirmative action is inefficient, if it is in fact inefficient, isn't enough to make affirmative action immoral either. Thus, the point here is that whether affirmative action leads to inefficiency or not doesn't matter for the moral issue, because nobody thinks that there's a moral obligation for an organization to be as efficient as possible. And finally, the affirming the differences between people variation. The argument here is that by recognizing that people are of different races and using that recognition to act in particular ways, governments and organizations are strengthening the racial differences between people. When racial differences between people are strong, it becomes more difficult to treat all people equally, and since treating all people equally is a good thing, anything that impairs our ability to do so would be a bad thing. However, governments and organizations can recognize racial differences in ways that are bad and in ways that are good, just as governments and organizations can recognize all sorts of differences in ways that are bad and in ways that are good. It's not the recognition itself that has the above-mentioned negative consequences, but what is done because of that recognition. For example, preventing racial discrimination in housing requires recognizing racial differences, but this recognition results in good consequences and not in bad consequences. In fact, we might think that treating people equally often requires at least the ability to recognize differences between people so that we recognize when some people are not being treated the same as other people are because of some difference between those people. In this lecture, we've looked at 9 topics. 1. Affirmative action and moral questions. 2. The 2 standard moral positions about affirmative action. 3. Boonin's non-standard position. 4. The argument from the right to be judged on one's individual merits. 5. The argument from the right to equal treatment. 6. The Overgeneralizations Argument. 7. The argument from discrimination. 8. The bad track record argument. and 9. The argument from the negative effects of affirmative action. Thank you.